this time from London. I'm indeed David Green, and I'm President of the Law Society of England and Wales. It's really good to be here and good to be with presidents of the UK law societies. We don't really get much chance to gather in this way, but when we can, certainly very useful. So I say that really pleased to be with Amanda and Rowan from Scotland and Northern Ireland, and I know that they will be speaking. We're lucky we share something actually as presidents of law societies, in that as presidents, well, presidents is a life of glamour. It's travel, it's dinners, it's receptions, it's grand events. And Amanda, Rowan, and I are indeed doing all that, albeit from our front rooms, our respective front rooms. So but it is a great, and actually the events, the pandemic, is obviously is of huge concern, but it has brought people together, and I think it's brought law societies actually across the world, not only in the UK but across the world together over the past few months as we face common problems. Before I go on to the TCA, the Trade and Cooperation Agreement, I just wanted to say a few words to those lawyers attending this event, who've made careers and indeed livelihoods practicing outside the United Kingdom. In many senses, you are ambassadors of the profession. It is you that provide the exemplary services that ensure the UK maintains its reputation as a global legal centre, whose legal advisors are a rock to cling to in times of crisis, and you are there effectively ambassadors selling the common law and indeed each of our jurisdictions. Some have suggested that without access provided by membership of the single market, the reputation will falter. But I disagree entirely in relation to that. And it's important if one thinks broadly. Law tech, for instance, we are at the forefront of developing law tech. We are at the forefront of developing IT, remote hearing, quick access to justice, and swift resolution of commercial disputes from around the world. Time and again, we have shown that the UK is committed to excellence in legal services and to the rule of law. It was only last year that professions united in criticism of the internal market bill, which the government rode back on. And that reputation is based on more than our membership of the European Union, and will endure through the changes that have been in motion since 2016. And just as you, those ambassadors, are playing your part in upholding the image of UK legal services, we at the Law Society of England and Wales are as well, through our Global Legal Centre campaign and our work with the government on their great campaign. And certainly I've been attending events for selling, marketing the jurisdiction around the world over the past few weeks. But let's just turn to the meat of the matter, the Trade and Cooperation Agreement. And I should welcome, actually, I won't name anyone, but I see the attendees. There are many here who have quite extensive knowledge of the TCA and the issues that arise in it. So I think it'll be a really useful discussion going forward. There we are just before Christmas. We're all waiting to see what Santa Claus delivered. I'm tempted to say Santa in the form of Boris, in the form of the final agreement, and out popped the Trade and Cooperation Agreement as our Christmas gift. The fact that we had an agreement was met with sighs of relief. congratulations for the negotiating teams, and anticipation of the published legal text that was to flow from it. Quickly, the Law Society of England and Wales was quick to set out a narrative for the legal services sector that is vital to see the deal as the beginning of a process rather than a monolith, as we find new ways of working in and with the EU. And indeed, when we first looked at the agreement, with much mention of legal services, we certainly greeted it with optimism. To some extent, as we'll discuss, is that concentration on legal services, the repetition of legal services within the agreement itself, was somewhat matched to pull it back, perhaps, to reality by the reservations and schedules that were discussed, which really push legal services back to issues of a domestic nature in the EU domestic jurisdictions. There is a dedicated legal services chapter, and it certainly sets a useful precedent for other free trade agreements. And indeed, we've been talking to government and framing what we want from other free trade agreements across the world. So it does give a springboard for those discussions, and indeed gives a springboard for discussions about legal cooperation, such as civil justice cooperation. Further, the principles within the chapter are welcome: advice on home country and public international law, the references obviously to arbitration, conciliation and mediation, registration processes that cannot be more burdensome than requalification, and the right to establishment. So as a foundation, it is certainly a good basis for future cooperation on legal services. But it is that issue about the domestic position in EU countries which brings it back. So to some extent, legal services gives with one hand the reference to it, concentration on it in the TCA, take it back with the other. Provision of cross-border legal services is subject to those reservations, non-conforming measures, national requirements, which vary from state to state. And these measures can pull back that general principle of home title practice for a given member state and may include restrictions on joint practice with local lawyers. So the true picture on market access is very much obscured by domestic regulation. And we're working hard to communicate our analysis, and here we are today talking about it, about those domestic reservations to relevant members. And there are obviously other concerns. As expected, civil justice cooperation isn't covered in the agreement, although criminal judicial cooperation is. We did secure a short transition for data under GDPR, but no decision yet on data adequacy. The fact that these crucial elements remain to be dealt with leaves lawyers, businesses, and consumers on both sides lacking a degree of confidence and stability that we need for trade to flourish. And we might just talk in due course about the uncertainty that is in the air at the moment. So there's no doubt that the three jurisdictions, the law societies, have a job to do and our work cut out for us for the coming months and years. We continue to urge the EU to support UK's accession to the Lugano Convention, and we know that I can see that there are many here in this audience who are only too familiar with the rise from the Lugano Convention. And we will parallel our work with national bars to clarify and liberalise requirements on UK lawyers wishing to practice in EU states. And we've already started that process by talking to bars, by national bars. And again, I'm sure that we can talk about that. As we have done since the referendum, we'll continue to support solicitors of England and Wales as they adapt to the new normal and champion the importance of the profession to the government, Parliament and the public. I think just to conclude is, going forward, there's often a phrase of, and I'm sure that the presidents and the chief executives who are attending will know the question from members, which is often, what does the Law Society do for me? In this area and in many areas, the Law Society has actually been doing a lot, and we're going to discuss that today. And we will continue to support our members, both within the jurisdiction, wanting to export services, but equally those in other jurisdictions in the European Union. I'm going to leave it there, and thank you very much indeed.
Thank you very much, David. If anyone has any questions, will you post them on the chat? I can then see them and pick them up as we go along. Next we have Rowan White, the President of the Law Society of Northern Ireland. Please, Rowan.
Well, good morning, Helena, and good morning, Amanda and David. It's good to see all of you again for the first time this year, albeit virtually. And thank you for the opportunity to join you this morning and to say a few words in relation to the what things look like from a Northern Ireland perspective. I'd like, if I may, to focus a little bit on the Northern Ireland Protocol, which you may or may not be aware of. And to understand that, I think it's first necessary to have a very short history lesson. One needs to look back to the Good Friday or the Belfast Agreement, which was signed on Good Friday in 1998 between the British and Irish governments and most of the political parties in Northern Ireland. That was intended to resolve the conflict, which is often known as the Troubles, which had continued unabated in Northern Ireland since 1969. As part of the Good Friday Agreement, both governments had agreed that there would be no hard border between Ireland and Northern Ireland, so no cameras, no border posts. But this was predicated on the unwritten but underlying assumption that both countries would remain part of the EU. The intention was that people and goods could move freely between the two countries, and for the most part that arrangement worked very well in practice. However, as a result of Brexit, a new arrangement was needed to ensure there'd be no checks along the 310-mile border that separates Northern Ireland and the Republic of Ireland. That border is, of course, the only land border between the UK and an EU member state, and for political reasons, it must remain as frictionless as possible. Hence the concept that Northern Ireland remains part of the EU single market for goods, while also remaining part of the UK's domestic market. The protocol is intended to mitigate the risk that goods originating in Great Britain could enter the EU single market via Northern Ireland without appropriate regulatory checks. And the protocol has the effect of more closely aligning Northern Ireland with the Irish economy than before, and that, together with the need for the regulatory checks imposed by the EU on GB goods entering Northern Ireland, has to some extent impacted on the confidence and identity of at least the unionist community within Northern Ireland. Matters have been exacerbated somewhat by a lack of preparedness or an unwillingness to adapt, or both, on the part of some Great Britain companies who previously sold goods into Northern Ireland. By way of mitigation measures, the EU and the UK have agreed to some grace periods to give traders time to adjust. For example, supermarkets and other food retailers have been given 3 months to adapt to the requirements of the new regime. Nevertheless, there have been many supply chain problems here, and complaints of empty supermarket shelves have been widely reported. The UK government's meeting the EU Commission tomorrow, in fact, to discuss the impact on Northern Ireland, and has requested lengthy extensions of the grace periods, no doubt buoyed up by the discomfiture which the EU is currently experiencing, having triggered and almost immediately reversed the emergency provisions in Article 16 of the protocol at the end of January. I'll come back to that in a moment, if I may. But first, let me give you a very brief flavour of the practical outworking of Brexit in Northern Ireland. Some products are now prohibited from entering Northern Ireland at all under single market rules. Somewhat surprisingly, for example, sausages and other chilled meats are on the banned list, but have been granted a 6-month grace period. Horticultural products are also banned, and others which aren't banned need a plant health certificate. But soil is on the banned list, so as it can carry pests and disease. So garden centres here are finding it difficult to obtain plants from GB suppliers and are having to turn to Ireland or elsewhere in the EU for supplies. Belfast's best known delicatessen, which normally stocks 200 cheeses, 60 of them from GB, reported last weekend that it can now only source 2 or 3 of them. So for the time being, at least, there'll be no more stinking bishop for the good burgers of Belfast. On a happier note, the Wine Society, which had to suspend deliveries of its vital products to Northern Ireland for a few weeks because of difficulties with its carriers, has now resumed supplies, much to the relief of its thirsty customers here in Northern Ireland. I'm being slightly facetious about this to make a serious point, namely that many GB-based suppliers, including the likes of John Lewis, for example, have paused or indeed permanently ceased supplying into Northern Ireland on the basis that the relatively small market here just doesn't justify the additional hassle and cost involved. All of this has resulted in a significant degree of disruption, both to consumers and to local traders, most of whom are SMEs and consumers and are ill-placed to cope with added bureaucracy and cost. UK government asserts that the disruption is in the nature of teething troubles. Many others suspect that it is more structural in nature and therefore likely to be permanent. Time, no doubt, will tell who's right and who's wrong on that one. On the other hand, some of the larger businesses, especially manufacturers, appear to have geared up in preparation for the protocol and are not only undaunted by it, but see opportunities to use it to expand their markets. Northern Ireland will find itself in a unique regulatory position in the new EU-UK trading landscape, and businesses here will have unfettered access into the UK internal market, while at the same time remaining in the EU single market for goods. So they'll face fewer regulatory hurdles to export into both the EU and British markets. In theory, therefore, Northern Ireland should be a good place for exporters to base themselves in the post-Brexit era. Early indications suggest that not only locally based manufacturers, but also some GB companies have realised this and are positioning themselves already to take advantage. If I may, I'll return very briefly to Article 16 of the protocol. This is a provision which allows either the EU or UK to suspend the operation of any part of the agreement that causes economic, societal or environmental difficulties. It was intended as a remedy of last resort, and it was therefore a major surprise when the EU invoked Article 16 at the end of January and announced that it would impose economic controls on vaccines leaving the EU. This was no doubt part of its wider dispute with AstraZeneca. However, this might well have led to new checks along the border in order to prevent EU-produced vaccines being shipped into the United Kingdom. This move achieved the very rare result of uniting the British and Irish governments and virtually all of the political parties in both parts of the island in an outcry against the EU's decision. And within a very few hours, the EU branded the decision a mistake and reversed it. The incident does at least appear to have resulted in a renewed enthusiasm on the part of the EU and the UK government to make the protocol work for the benefit of all the people of Northern Ireland. However, it's notable that the UK government has stated in recent days that it's prepared to invoke Article 16 if and when it appears appropriate to do so. So that is not necessarily a good omen. So overall, it's been a pretty mixed bag so far. A few other points in closing. The UK has, of course, lost access to the EU judicial cooperation measures in criminal, civil and family law. And the loss of the European arrest warrant in particular will be actively felt in Ireland, where it helped eliminate the political sensitivity of extradition between the two parts of the island. So far as lawyers here are concerned, the complexity of the protocol and the loss of the EU judicial cooperation measures will undoubtedly generate an increased demand for legal advice. And if local and GB-based companies do upsize or relocate to seek out new opportunities within the EU, that should also see an uptake in traditional areas of work such as corporate, commercial, employment and property. And finally, as one of the EU measures disrupted by Brexit is the loss of the Lawyers Directive, underpinning free movement of legal professionals and the mutual recognition of professional qualifications within the EU, the Law Society of Northern Ireland entered into a mutual recognition agreement in the form of a Memorandum of Understanding with the Law Society of Ireland in May last year. This will secure continuity of legal services on the island of Ireland. Northern Ireland was the first jurisdiction identified as having a corresponding profession by the Law Society of Ireland. And importantly, that was recognised as long ago as 1954, some 3 years before the signing of the Treaty of Rome, and some 19 years before accession by the United Kingdom and the Republic of Ireland to the European Economic Community in 1973. So in effect, what our MOU has done is to restate and update the arrangements which applied immediately before accession to the EEC in 1973. One practical manifestation of the MOU has been that Northern Ireland is unaffected by the recent decision by the Law Society of Ireland no longer to issue practicing certificates to solicitors qualified and resident in England and Wales and in Scotland. We currently have some 300 or so solicitors who are on the roll in Ireland, with about half of them holding Irish practicing certificates. I think that's probably all I have time to say at the moment, Helena, so I'll leave it there, if I may, and pass over to Amanda.
Thank you very much, Rowan. And indeed, Amanda Miller, President of the Law Society of Scotland, please.
Thanks, thank you. Thanks, Helena. Still morning in Scotland, and given the way the weather has been, I'm delighted to be able to join you from Perthshire this morning without having had to dig out my car from about 18 inches of snow. It is great to be speaking at an event with Rowan and with David, and have that opportunity to talk to as many people as are here today. The numbers being quite significant, as I understand it, perhaps more so than they might otherwise have been if we'd all been dealing with flights in-person events. So from the Law Society of Scotland's perspective, and moving to the circumstances you talk of today, from our perspective, since the referendum in 2016, we have had a rolling action plan objective to continue to provide leading non-partisan voice at various stages of the UK's departure from the EU. And from the Law Society of Scotland's perspective, this work has broadly been divided into 4 main areas: policy and legislation, trade negotiations, member communications, and impact on the Law Society of Scotland's operations. And although the UK has now left the EU and the TCA has been agreed, those will continue to be our priorities for the foreseeable future. From a policy perspective, there is still Brexit-related legislation either making its way through Parliament or still to be introduced. And much of this will have an impact on devolved matters and will also require engagement in the Scottish Parliament, where legislative consent may be required. As UK policy develops, respecting retained EU law, there is likely to be a steady flow of new legislative proposals, and we also expect parliamentary inquiries on such proposals. From a trade perspective, now that the UK has left the EU, negotiations, as you've heard before, with other countries will continue unimpeded, and we will provide input where necessary. There is also likely to be continued engagement with government on the practical issues surrounding implementation of the TCA, on the aspects that do concern the legal sector, for example, the mechanism of recognition of professional qualifications, as we've already touched on, and the provisions of limited delivery of cross-border legal services. In terms of communication, for us, regular communication with members will be necessary to help them navigate the new environment in which we are all operating. This includes a lack of provision in the TCA for civil judicial cooperation, while we await the EU's position on the UK's accession to Lugano Convention, which the Brussels office has led the work on. Communication from our perspective has been mainly through our fortnightly e-newsletter, Law Scot News, and our monthly journal and updates. For anyone looking at hours in, opportunity here on the 4th of March on law, jurisdiction and enforceability post-Brexit, and again, family law, corporate practice and data protection. We have the UK withdrawal from the EU Continuity Scotland Act of 2021, the Passage Act, which became law on the 29th of January. The Scottish Government has set out its commitment to ensuring that Scots law continues to align with EU law to the greatest extent possible post-transition. For us, this Act will enable Scottish law to keep pace with future developments in EU law. It will also allow changes to be made to retained EU laws which are already operating in Scotland. This applies to areas of law that are devolved to Scotland, such as the environment, agriculture and fisheries. Lots of talk in relation to fisheries following the departure from Brexit and the departure from the EU, and I'm sure that that will continue. From our perspective, the bill does three main things. It gives Scottish ministers power by regulation to help devolve law in line with EU law, ensure Scottish ministers and public bodies pay attention to environmental principles when they make policies, and it sets up a new organisation to replace the oversight of environmental law provided by the EU. Following the end of the implementation period on IP completion day, retained EU law replaced existing EU law, and the EU can no longer make law which is binding in Great Britain. Rowan has already covered the distinct position for Northern Ireland. However, the UK can, by choice, create law in the future which reflects new EU laws in the relevant areas of retained EU law. The UK can also make law which departs from retained EU law. In devolved areas where the EU might legislate, the Scottish Government and the Scottish Parliament are empowered by this new Act to legislate to keep pace with EU law, although it may be some time before this legislation is put to practical use. The Act also covers environmental law. The EU has core environmental principles which, when it brought into Scots law, the environment, it also set a new guiding process on your relation with environmental standards Scotland, which will be one of the bodies in Scotland. Environmental law, environmental in Scotland is effective and in protect the environment and their well-being. From a Law Society of Scotland perspective, while we have expressed no view either way on the need or desirability for Scotland to keep pace with EU law, we did point out the importance of ensuring that any significant departure from or development to existing domestic law is given sufficient parliamentary consideration without prejudice to the domestic legislative agenda. It will also be interesting to see how this legislation interacts with the common frameworks between the UK and devolved administrations, and also the internal market principles as set out in the 2020 UK Internal Market Act. So from the Law Society of Scotland's perspective, what now? We know that we have left the EU, but not Europe. Then the links of business, culture, family and friendship will remain. trading goods and services will continue between the UK and the EU, even if they are at lower levels now than they were before. Notwithstanding rounds discussions about thinking I'm pleased to still moving. Sure that considerations. There will be more domestic law that we can advise on. Clubs will also continue to need advice. From the Law Society of Scotland's perspective, we've managed to hold on to participation on areas of mutual interest, and we also EU colleagues on the elements of the TCA that pave the way for further development of the recognition of professional qualifications. As for the future, that is the domain of metaphor, cliche, pick whichever one suits your frame of mind. We are in an uncharted territory. We are in an unsettled time. There are new opportunities. There's a bright future ahead. We are in very uncertain circumstances, and certainly in relation to this, uncertainty abounds, but there are constants which we can grab a hold of: the rule of law, the democratic engagement, the needs of the client, and the expertise and ethics of our profession. For us, for me, as President of the Law Society of Scotland, those have been the stars and will continue to be the stars by which we will navigate the future. They will be unchanging. Hopefully they stay fixed and secure. And I'll pass back to you, Helena.
Thank you very much, Amanda.
Hopefully.
I do have a question already posted on the LPP, but if I can get back to that a little bit later. Can I ask again, switching off your cameras and your microphones for those of us who are not speakers? We're just trying to preserve bandwidth for everyone. Thank you. Good. Just a few perhaps final thoughts from the Brussels perspective on what is happening now and what is happening then next. As all the three presidents have said, this is we are heading into a new direction essentially from this. The TCA, what we have, it was of course a good achievement before Christmas. It was very much needed to avoid that no deal space that we were politically looking at. And in that sense, the TCA, of course, sets out a framework for the basic trade on goods, basic trade on services. Northern Ireland, specific provisions already, of course, from the withdrawal agreement that apply, but then we will look at the rest of the UK relationship now through the TCA lens. And as all three presidents have emphasized, is that actually the TCA does not solve absolutely everything. What the TCA sets out, in particular for services, is a framework where you move very far from the world that we used to know, where you had the mutual recognition of qualifications, where you had the freedom to provide services. Now we're in a world where we have some enabling provisions, both for legal services and then for mobility issues, but then we have to look at those national reservations. So there is still work to be done with that respect. On mutual recognition, of course, there is fully work to be done because the TCA simply sets out a framework to agree mutual recognition agreements. So this means the recognition of qualifications. We would still be looking at further discussions and negotiations. But as all three presidents have emphasized as well, there are also other provisions that are of interest to all three law societies and our members. Going beyond the legal services, we have been connecting on a range of issues with our membership as to what are those key issues for them. And of course, what we are looking at now crucially at the beginning stages in particular is what will be happening to the data adequacy decision. We have a temporary provision in the TCA which only builds a bridging provision towards that European Union data adequacy decision. As has been pointed out, the recognition enforcement of civil and commercial judgments, that's not included in the TCA. We never expected it to be because it was never part of the negotiation. It was not part of the EU negotiation mandate. It was not part of the negotiation texts. But we are looking to hear what is happening with the Lugano Convention in particular. That's the EU EFTA Convention that would solve the recognition enforcement matters between the EU and the UK. And it would not be simply in the interest of course, the litigating community, but rather it's in the interest of the businesses and individuals who are caught in cross-border claims as to have this matter solved. So it's about access to justice from all of our perspective rather than simplistically litigation business sense. So these are the issues that actually we are looking at, and that's where the Brussels office continues to collect intelligence, continues to have those discussions on behalf of our membership, the UK solicitors profession here in Brussels. And we hope that we can then build on this, the very basic framework that we have now in place as the cooperation between the UK and the EU. We can build on that, then further forms of cooperation that will then deepen those contacts again. Now, of course, this all political will matters here, naturally, and this is in the hands of the negotiators. Therefore, it is very difficult to predict exactly at this point what will be the direction of these negotiations or the timeline. However, what we can say is that there will be a lot of discussions to be had following now when we have now that the TCA is in place, but we will be also indeed continuing to further areas of discussions on cooperation. That's clearly set out also in the DNA of that agreement. Now, any further comments from the presidents before we move? We have one question on the LPP. Any other questions? Can I
just say, Elena?
Yes, David, please.
Yeah, okay. Well, I was just going to say is you've touched upon the future cooperation and working things out, and I think what we're all presented with is. And for instance, Northern Ireland and Scotland as well is a much more clunky world, is how I might put it, that we haven't yet quite worked out how we're going to deal with certain problems. And privilege, I think, is one of those that, for instance, someone has raised, and obviously is an important point is, and we might come on to technically. Yeah, we'll come on to privilege separately. But FIFO, for instance, fly in, fly out, it is a matter yet to be really resolved. And as someone has asked, is what if I phone someone? You know, what's the position then? You know, I don't fly in, fly out. I just speak to them on Zoom or something of that nature. And I think it's those that we haven't quite, the profession hasn't yet quite worked out. In terms of establishment, certainly the larger firms have undertaken processes over the last few years since the referendum to deal with their own establishment, how they set their offices up depending on the jurisdiction, what they're doing in relation to the transfer of qualifications. And I think a lot of the larger firms are already there. For smaller firms, and I include my own in that, is I think we're still working on that, our relationship, and this is unfortunately a period of uncertainty. in which there's much work to do in really trying to smooth out that additional clunkiness that's going to be necessary over the next few years.
Absolutely, David. It's those questions we have not actually learned to deal with because we have been in the internal market system, which tied all these questions together into one bunch. So you didn't have to worry about migration, you didn't have to worry about provision of services, you didn't have to worry about qualifications. Now, all of these are essentially different strands, and that creates indeed the clunkiness, the complexity of this agreement. So if I look at it from what you said about the FIFO perspective, we need to discern the case. When can you give legal advice? And I see we have a question. That then depends what type of legal advice and who are you advising on. That answer depends on that. So if you go, I see the question saying, if you go to France, give advice on EU competition law. Now, it depends on the French regime, whether that's allowed or not. If you come to Brussels, I can tell you the answer because I'm much more fluent on what is at the Belgian scene. The answer is actually under the domestic system, you can give legal advice. Legal advice is not a reserved activity. However, if you act in front of the EU institutions, then that's another layer of complexity. And that's something that if you have simply a UK qualification, you don't attract the legal professional privilege anymore in front of the EU, and you cannot represent clients in front of the Court of Justice in new cases.
Yeah.
So that's the question. And then added to that, of course, then there's the physical movement, which has been now very complicated with COVID. You have the migration rules on top of it, where the TCA says something about exemptions for business visas, but then there's an exception to that exemption, essentially for paid services or paid activities.
Yeah.
David,
I mean, I think it's worth saying, Helena, that we're used to dealing with the European Union and the European Commission as one within the single market, and I think it's important for everyone. I'm sure they do understand this. Is that we are now really driven down to the domestic level in many of the aspects that come out of this, out of either the TCA or our departure from the single market. And privilege, for instance, privilege domestic, is I mean, subject to the point you make about the European Union and the Commission, and privilege that applies to that type of work is otherwise privilege is usually a domestic matter. And it's going to depend on the domestic regulation of privilege, which changes from country to country. For instance, it changes depending whether foreign legal consultants are recognised. So it is quite a. So we're so used to the single market and indeed the competence of the European Commission at that sort of level, that unitary level. And it's being replaced by different domestic regulation, just as we were talking about. Indeed, it's in the appendix to the TCA in relation to legal services. It is those restrictions at a local level, and I think the general advice is that the Law Society can provide a degree of guidance. As we do in relation to different countries with different aspects of the legal services market. But ultimately, firms are going to need to think about getting domestic advice within those jurisdictions to really get a clear picture of restrictions or what they have to do.
Absolutely, and what we are trying to do, of course, in our guidance is signposting. So we do know about legal services to great extent, but like has been said, now also the questions of mobility, the visas, the immigration issues rise. So we are looking to post, for example, into our Brussels website and our guidance on where you can find that information. I know that the UK embassies, for example, are working on this at the moment. So it's worthwhile contacting them on those immigration issues if they rise, because they would be knowing what is the situation in a particular country. So that also creates then the layer of complexity in relation to who can give you the right advice on the right question. Any other comments or questions? I'm not seeing anything coming up on the chat. You do know the chat function. Here we go. We have another question. UK solicitor qualifying in 2021 or later, working in their firm's EU offices. I think that refers now to those who have fallen under the withdrawal agreement, those who benefit from the withdrawal agreement. That's actually a fairly limited class of people, as we understand at the moment. It's those who have been requalifying to a European profession. Whereas those who come in 2021, it is the national, then you look at the national legal regimes. You want to make a comment maybe about the national qualification issues? I know, David, you looked at it a lot in the Law Society of England and Wales.
You mean this is requalification? I'm just trying to understand. Yeah, Article 28 of the withdrawal agreement. I think what is being asked is what happens if someone's qualifying now post Brexit,
yes,
or post the end of the transition period, the question of what their position is, that will depend on the domestic regulation. And the openness of the domestic regulation, your ability to practice it in the country. For instance, Belgium is relatively free in those terms. Other jurisdictions are much more restricted. Greece is restricted. So that again will drill down into the domestic position on relation to foreign legal consultants. For instance, France has a band of foreign legal consultants, and the question is at the moment is in negotiation with the bar is how that's going to apply to UK qualifications. But again, it's very much drilling down into the domestic circumstances. And the law societies, I think across Northern Ireland and Scotland, we're all talking to the local bars to see how that is going to work in those circumstances.
Maybe Rowan, do you have a comment from Law Society of Northern Ireland, how you see this?
Well, Helena, it's we have historically had relatively few, if any, indeed, lawyers wanting to practice in the EU, other than in Ireland. So we, as I've indicated earlier, we had addressed that by the Memorandum of Understanding, which we reached with the Law Society of Ireland last year. I was interested when you and David were referring to FIFO. We have DIDO, which is drive in, drive out. We don't need to fly in and fly out. So that is the principal area, or that would have been the principal area of concern. We identified that fairly early on, and we were discussing that with the Law Society of Ireland from, I think, late 2019, and very, very quickly reached a sensible agreement with them. And needless to say, being lawyers on both sides, it took us a little while to dot the I's and cross the T's before we got it signed off, virtually, of course. last May. So I think that is really has been the focus of our concerns over the last period of time, which is not to say, but it is fascinating to hear what David has been saying about the position in other parts of the UK, which it's obviously a much more prevalent issue than it is here.
Good, thank you. And Amanda from Scottish.
Yeah, I think. Thank you. I think following on from what Rowan was saying in relation to numbers as well, it's a much more significant issue, I think, ultimately for the Law Society of England and Wales. Our numbers are such that we are dealing with cases essentially on a case-by-case basis in terms of individuals. But I think the other thing, the reality, while we might have lost various rights, the expert team, they've wanted to understand and work within the systems haven't gone. We have lawyers from other jurisdictions working within the EU who didn't have those rights, who have managed to find levels of workarounds. And the reality is the legal profession is full of ingenious and creative human beings who are incredibly well trained and thought-provoked in those respects. But certainly what David is saying in relation to dealing with cases on a bar by bar basis at the moment, that's the situation we find ourselves in. And certainly I had a conversation with somebody yesterday working in Spain, and they're liaising with their bar about being able to make use of the time that they've already been in Spain, and working with them, and certainly from our perspective doing what we can to assist on a case-by-case basis, and really sharing that information and getting the information, because we're all in this kind of scenario of we're not really very sure, because David describes the TCA as some form of Christmas present, but it came at very short notice with without real understanding, etc. So we're all in this situation of trying to unpick, understand, see where it might take us, and I think that collective effort will continue to be important.
And I'll just add to Helena, because there's a sort of question about it, is the issue about EU lawyers in the UK. Certainly, I can only speak for England and Wales, is that we remain a very open jurisdiction and subject to immigration issues, which are, of course, more complex now, but subject to that is an EU lawyer can come and practice EU law, they can practice their own domestic law in the UK, in the England and Wales. The only restrictions is that they would need to re-qualify, and of course we don't have RELs anymore. We don't have registered European lawyers. We now have registered foreign lawyers. So it is a different regime. But subject to that is that the restrictions are on the reserved activities, litigation, for instance, other five reserved activities that an EU lawyer can't do within the jurisdiction. So those we remain as free as possible for EU lawyers to come and practice here, and that hasn't changed. That there are issues that's quite important, because when we look at other jurisdictions, reciprocity is often an issue. And indeed, at one point, I know you and I had the debate, and we had debate across the UK, was, should we actually close the system so we've got some sort of leverage over that reciprocity? But we decided no, is because we want to remain a global legal centre. We want to remain very open for EU lawyers and lawyers from around the world to come and practice here. So that's position. Unfortunately, many domestic EU regimes are not to that effect. And we remain to be seen. I'm interested in Rowan's point about Ireland. I'm tempted to say one of the questions that people will be asking is, I'm tempted to say it's PIPO or ZISO, which is zoom in, zoom out. or phone in, phone out, and I think that's that's an issue. But I think all these things is we can see the real importance of domestic legislation within the European nations.
Helena, could I just say that in relation to RELs, the Law Society of Northern Ireland took a conscious decision to allow those who had registered here before December 2020 to complete their 3-year qualifying period and to remain and work in Northern Ireland. So just to make that point, that we don't have very many of them, I have to say, but those that there are, that's the rule that applies now to them.
Good, thank you very much. We have a question earlier about the remote advice, as David, you raised that as well, that whether we're going to be having a Zoom-based provision of services. Is there any clarity on remotely providing advice, or is that one of those issues that we're just tackling at the moment?
Do you want me to take that up, Elena? I don't want I don't want to be the one that's speaking messages. The answer is I think it's one we've yet to sort of tackle. I mean, FIFO has taken a place for forever. Since there were planes or maybe ferries or whatever it is, lawyers have gone to other jurisdictions around the world, and I mean US lawyers come to Europe all the time in order to give advice, usually about US law. So that it has happened, and it's a very difficult area to police for regulators, local regulators. And when it's ZESO or ZESO, I think, or TITO, maybe teams in, teams out, something. I don't want to be biased in the method of communication. But when it's that, it's because it's even more difficult to police. But I think you do have to look at two things: local regulation. Whether in some fashion the client is causing has a problem, that you're causing the client a problem, and the second is privilege. Does privilege attach to that advice? And I think those are the at least two of the issues that solicitors will face.
Thank you. Any other regulatory perspectives? Maybe Amanda or Owen?
Yeah, I mean, from Scotland's perspective, as far as kind of requalifying is concerned, etc., in Scotland historically, our EU lawyers have chosen ultimately to requalify through our examination process as opposed to through the establishment directive, and as a relatively open jurisdiction, not as alluded to by David in relation to England and Wales. Certainly Scotland, we see ourselves as an open jurisdiction, and we expect that to continue. Only time will tell in relation to the numbers. I think as far as the depending on where you're giving the advice from question is, whether it's in your home office in Perthshire or in Spain, etc. The fundamental issue at the moment, certainly I think I agree with David, will be that issue of privilege in relation to the jurisdictional challenges, but it's certainly something for us all to be looking at, and it would be helpful certainly to have more guidance on that. But again, that feeds back into, at the moment we are still in the very early days of knowing where we're at and how things are going to play out. I think sometimes some of the information that's come from those who signed off the TCA, their interpretation is very different from those of us who are now ploughing through it, trying to work out what the applications actually are. So it will be a time will tell situation, but that protection of privilege, I think, is going to be really important, and one of those big considerations for all of us when looking at giving advice elsewhere. I don't know if Rowan's got anything else.
No, thank you. That's the key point. Rowan.
No, I agree with what Amanda and David has said. I mean, as far as we're concerned, I'm sure the other law societies are the same. We have spent the last 12 months or less than 12 months pivoting completely to doing everything online. And just actually physically achieving that has been some task in itself. There are undoubtedly ramifications to doing that short term and longer term. And I think there are still some aspects of it that need to be worked through and the consequences explored more fully. But hopefully in the not too distant future, as the pandemic abates, we'll have more time to turn our minds to issues of that kind.
Good, thank you. I have a couple of Law Society of England and Wales specific questions. One on the SQE. Do you see, David, or foresee, sorry, the introduction of the SQE impacting on reciprocity issues? And then secondly, a question about the continuing of the REL status and integrating those lawyers who have possibly more experience in England and Wales than the
let's deal with SQE.
Yeah.
I mean, the SQE actually, and this question of requalification is really for the SRA. It's for the regulator, just as it would be in any jurisdiction. The SQE could have an effect. I think I have seen some issues arising in relation to the SQE and qualification and reciprocity. I think the problem at the moment is it's a bit early to say on SQE. We can only negotiate with what we have, but I have certainly seen one or two jurisdictions that remain nameless talking about, oh, what about the SQE? How does that affect that reciprocity issue? And I think it's early days yet, but it might do. Let's see on that. As far as the admission is concerned, and I note the question about the SRA refusing. Certainly, again, it's a regulatory issue. We are pressing. We do have calls and a lot of dialogue with the SRA, and continue to do so. And indeed, we need the SRA's cooperation in relation to requalification, for instance, the recognition, mutual recognition. So they're very much part of that, but they do have that independent regulatory role. And we certainly, from a law society's point of view, representing members, is a press for ease of recognition, an open system as far as possible, and we do press that on the SRA. I can't talk about that particular issue you raised, but you might want to come to us and raise it with us just as a general point, so we might take it up with the SRA.
Good, thank you, David. No, I feel like sometimes as well that when I'm talking about the requalification or the system, what can you do in the UK jurisdictions, that sometimes the message is it's a lost in translation. That because we end up emphasizing the laws that these are the restricted activities, whereas we should start from that actually everything else is allowed apart from these few things that are restricted activities. So I think there is a lot you can do in the UK jurisdictions, and only very few areas are limited essentially. And what would give you a reason to requalify? We have a question on the Lugano now in the chat. It is a good question. We do expect and we hope that the Lugano Convention would come into force. The 1-year approval period that is prescribed in the Lugano Convention, that's just an indication that the parties should strive to give their opinion within the 1 year of the process. Now, the UK applied on the 8th of April last year, so we know that the 1 year is coming to an end in the beginning of April. The EFTA countries have already indicated that they would support the UK's application, and at the moment we are waiting for the EU to publish its opinion on the application. Now, there is no obligation for the EU to move or the parties to move quickly on this. There is only an encouragement in the Lugano Convention. The good news is that if the EU and if the parties say that the UK can accede, then the accession process will happen very speedily, because there is a facilitation provision in the Lugano Convention that allows then just for the UK act of ratification to be deposited, and that would seal the UK's accession into the convention. So you don't need to wait for a second round of ratifications anymore with all the parties. However, at the moment, the issue is at the EU's corner, and we are waiting to hear from them. Now, of course, our position is that it should come, and it does protect the businesses, it does protect the individuals who have cross-border dealings. It's just the fact that these continuing business relationships, there will be a lot of disputes, and not having a solution to that issue will be a cost issue, will be a resources issue for those businesses and individuals. Do you have any comments on this, David, Amanda, or Rowan?
Yeah, let's let Rowan or Amanda.
Sorry, can you hear me now? From a Northern Ireland perspective, I mean, it's clearly joining the Lugano Convention is one of the main priorities that we would see. We think that has to be top of the list. So it's speaking as a non-litigator, Helena, I'm fascinated to hear your expert exposition of the process, and let's hope it does go through as quickly and smoothly as it could do in the circumstances.
Thank you. And is there a problem also with what's the situation between the judgments with the Republic of Ireland and Northern Ireland on this?
We don't have any special arrangements in relation to recognition and enforcement of judgments between Northern Ireland and Ireland, I'm afraid. So it is important. Obviously, there's a lot of cross-border work, so it's particularly important in that respect. Never mind anything else across the rest of the EU.
Thank you. Amanda. Are you seeing some technical difficulties here?
Possibly, yeah. Shall I just, whilst Amanda's sorting that out, is I have, I must say, I've mixed views of the prospects. On the one hand, it makes absolute sense for the European Union to allow us to accede for small businesses, for consumers, just generally. My concern at the moment, and I think it's a growing concern, is that the EU sees this as a negotiating tool, as a political tool, and particularly we've had this argument about the Northern Ireland Protocol, as you've been talking about there, Rowan, is that the politics is quite hot and I think we have a concern is that as the politics hots up, it could have an effect on the agreement for accession. So I must say at the moment I'm putting it 50-50 as to whether the European Union will allow us to accede. But let's wait and see. We should have an answer by the end of March, shouldn't we, Helena, from the European Union? That's concept. Yeah, you know, they might kick it into the long grass. I think we'll just have to see. Do the Hague Conventions help? Well, the Hague Convention obviously is rather limited in its scope on recognition and of contractual terms. So it's quite limited in its scope. You know, we want Lugano, and you know, for the ordinary consumer, is that I think that is a really important accession. As Rowan says, it's up there as number one, and I'm pretty sure it's quite close for us as number one, exactly the same, Rowan.
Yes, am I seeing Amanda? I think you are now unmuted.
Ah,
yes, very good. Sorry, technical issues. And now you're back on mute. That is
that's
Yes.
annoying.
There
Is that
we are.
it?
you're back.
Okay. I mean, certainly from our perspective, as far as Lugano is concerned, we see it as important. It's important for EU citizens as much as, which is really what you were alluding to earlier, Helena, in relation to that accessibility for citizens and that real level of importance in that sense. So certainly from our perspective, we absolutely see it as important for all of our citizens, whether in the UK and in the EU, and I think it's fair to say, particularly for the EU, and having that level of understanding. But I don't really have much more to add beyond what Rowan in particular had to say, and David. Assuming you could hear me, because I can't see anything now either.
We can see you and we can hear you.
I can see you, yeah.
Yes.
See you, Amanda.
Good. It's sorry, you're back on mute, Amanda.
Hello.
Hello. Yes.
Yes. Okay. Lovely to know that you're all there, even though I'm facing a blank screen and apparently an open. But anyway, moving on.
Yes. Thank you. No, it's sometimes the technical issues are still.
Yeah.
Issues. I do miss meeting people in person.
I make all sorts of different faux pas when you see me in person than I do with technology.
It's fine. Good. I think on the Hague Conventions, just on a note as well, the biggest obstacle is the jurisdiction rules. It doesn't contain them. Even the Hague 19 does not contain them, which is a very new convention. It's untested. We don't know how it would work in real life because it's not in operation yet, and it excludes competition and antitrust. So in that sense, it's a far more limited scope. Now, of course, it would answer to key questions for the commerce. So the current Hague 05 that's in place, and it does apply now between the EU and the UK. That applies only in very limited circumstances where you have a exclusive, so-called exclusive choice of court agreement. And that excludes all the hybrid court agreements where, for example, you have partial arbitration, litigation clauses, or litigation in different countries relating to different clauses. So Hague 19 would be responding to that. And of course, we know that in commerce in particular, you would have the inclusion of hybrid choice of court agreements would be helpful for a long way. However, of course, we don't even have opinion about that at the moment from the EU. So we will just have to see what happens in this space. And what we are trying to do here in Brussels is we're actually talking with a lot of stakeholders. We're talking with a lot of business organizations, highlighting how this is a matter for them, or consumer organizations, how this is a matter for them, not just simplistically a matter for the legal profession or matter about the litigation. So we are just trying to make everyone aware of this, which has been a bit of a work because this area has worked so well throughout now the 40 years of period that we've had the Brussels Convention in place, and follow up Brussels Regulation, the extension Lugano Convention. So essentially almost the problem has been that the recognition enforcement of judgments has been so automatic under these systems that this area is not in awareness that there could be complexities, huge complexities with regard to recognition enforcement of judgments.
It's worth saying, Helena, is that one answer for those drafting agreements is to rely on the New York Convention, so provide for arbitration in agreements. And arbitration is actually quite an interesting world in post single market, because I think we will probably see in this jurisdiction a growth of anti-suit injunctions that were effectively forestalled whilst we remember the single market, West Tankers and all those cases. And we might see that, but I think what we may see as a result of this is a growth in arbitration clauses within agreements which provide jurisdiction and they provide for enforcement under the New York Convention.
Indeed, it's arbitration coming back to Europe more, and then of course choice of court agreements, getting them reconcluded for 2021 in an exclusive format, so then you can benefit from the Hague 5.
Yeah.
Good. I think we are coming to an end now. I'm seeing there's one more comment on the SRA, but maybe that's something we can pick up separately. With the person concerned.
Yeah.
I want to thank you all. And well, first, of course, ask, do you have any final comments you want to make? Closing comments?
Simply from Scotland's perspective, it's a brave new world. We are creative, we are thoughtful, we will find our way through this.
And from Northern Ireland, we're equally brave and equally thoughtful, and we, like Amanda's people, we will find our way through. We do. I mean, in terms of priorities, Helena, as I've indicated, the top priority probably is the Lugano Convention, as far as we're concerned. We'd like to see a favourable ruling on data adequacy sooner rather than later. And then the bilateral access arrangements and mutual recognition is clearly important. Although, as far as we here are concerned, we feel we've already sealed that off with our most important market, namely our neighbours in Ireland. So thank you for that.
I would just say is that you can find out what the Law Societies do for you on their websites. And if I might just advertise the England and Wales website at lawsociety.org.uk, and you'll find quite a lot of the guidance on there, for instance, legal professional privilege, rights of practice, or other issues arising, GDPR, other issues arising and we continuously update those as we go along in this post transition period or TCA period. Do have a look at that, and I hope that will answer many of the questions that might be put.
Good, thank you. Indeed, we try to post information, then also signpost into all three law societies, back to your information from the law societies, also into our Brussels website. And keep an eye out also for our Brussels agenda. Anything new, anything we figure out what's new under the TCA, we'll be also putting that into our newsletters.
Yeah, and can we just say, Helena, just thank you to those that have organised today. Thank you to you, the Brussels office. We all rely on the Brussels office substantially, and a lot of our expertise comes from that. And I see that Anna and Rita are on, but others from the Brussels office and you leading them. It's a really fantastic service to the profession throughout the United Kingdom.
Thank you, David. Thank you, Amanda. Thank you, Rowan. And thank you very much for joining us today.
Stay safe, everyone.
Thank you.
Thank you.